Welcome to the Steadyhand Cafe, where we dive into topics that you've told us are on your mind. They may be directly related to investing or perhaps more general finance in nature. Today, we're digging a little deeper into estate planning with two subject matter experts, Julia Chung, co-founder of Spring Plans, and Lucy Main, co-chair of Wills, Trust and Estate Planning at Weirfoulds. Welcome back, Julia and Lucy. As you know, you are back by popular demand because our full hour session on estate planning a few months ago proved enormously popular with viewers, and they simply want more. In this, one of a three-part follow-up series, we touch on the most frequently cited area for information, and that was the topic of probate. What is it? Why does it garner so much attention? And how can you best deal with it? Lucy, why don't you kick things off, and then we'll hear from Julia.
Sure. So most provinces across Canada have some form of a probate process, and it's effectively a way of proving the will. So, or if there is no will, appointing the administrators / executors to act. And so it's a court process where you submit a series of documents, including the will and death certificate and an application by the administrators or the executors. And you end up with a document, a grant of probate at the end, which then allows you to go and deal with the assets with third parties. If you have a will and you're the named executor, your authority comes from the will. It doesn't come from the probate document. It's just that third parties often won't deal with you until they have that grant of probate, because otherwise they take on some liability in case there's another will out there, the person hasn't really died, something like that. And that's because in most provinces, certainly the common law provinces, we don't have registries of wills. And so there's no government registry of your last will. And so the probate process gives that comfort to the third party. People in some provinces get very exercised about probate. It is not a huge issue in some provinces, particularly provinces where there are not high probate fees. But in Nova Scotia, Ontario, BC, and some others, we do have significant probate fees. In addition, at least in Ontario, it's a long process. It can be anywhere from easily 4 to 8 months to get that document, depending on where in Ontario and what time of year and what's going on at the courthouse at that time. So most people get, at least in those provinces, get very exercised to find out ways that they can minimize and avoid both the probate process, because not only does it take time and things are frozen, but if there's real estate, you're incurring additional costs, property tax, maintenance fees, until you get probate and you can sell the property, and that percentage. So in Ontario, for example, it's 1.5%. So for every $1 million, it's $15,000 in probate fees.
Okay. And people get really exercised about that.
Yes. Yeah. So people don't like that. And so there are ways to minimize it. And the way I look at it is how much work and how expensive is it to avoid the probate process and the probate fees, and how much do you save? Because in most cases, it's simply a business case analysis, like cost benefit analysis. So there are a number of ways where you can reduce and avoid probate. And some seem simple, but they're actually not. And so the main one that most people use is joint ownership. Very, very common. Right. And I should say I'm an Ontario lawyer, so these are Ontario approaches, although many will work in other provinces, but there may be nuances to it. So joint ownership, if it's right of survivorship, you and your spouse own the house. By operation of law, goes to the other on first to die. Doesn't go through the will, no probate. The big misunderstanding out there is that is not necessarily the case when there's an adult independent child as the joint owner. There's a presumption of law that it comes back to the estate. And so unless you have done further planning and documentation, simply adding a child as a joint owner does not necessarily result in probate fee savings, and in fact can result in litigation. The number of times where there's, say, 2 children, the parent adds one as a joint owner thinking, okay, that takes care of that child and the rest of the estate goes to the other child. That's not automatically what happens, and that's where we can have disagreements. Beneficiary designations, RSPs, TFSAs, RIFs, personal life insurance. You can name a beneficiary and that goes outside the will. The thing to be concerned with there is for RSPs, generally speaking, that pays to them pre-tax. So if you have $1 million RSP, you name son A to receive it, they get the $1 million. But in the will, if you say daughter A receives the balance, the tax, which can be quite significant on an RSP or RIF, is paid out of the estate. So there's a mismatch. So you have to be thoughtful about that. So yes, you avoid probate, but you may have provided an unequal distribution amongst your beneficiaries. So those are the more simple ways to avoid probate. There are more complicated and more costly ways to avoid probate as well, that we can talk about and explore, but those are the more simple ways.
Awesome. And the reason we're having this follow-up session is because a lot of people heard Julia say in the first hour-long session that there are ways to mitigate, avoid probate, and you've covered some really great ground, Lucy. What else would you advise your clients, Julia?
Well, I think the first thing is to remember that as scary as probate sounds, oh my God, what is this thing? It is 1.5% in Ontario. It's 1.4% in BC. I think it's like 1.6% in Nova Scotia. It's 0 in Manitoba. It's a flat fee in Alberta, which is pretty low. I mean, when we're looking at these probate fees, I mean, yeah, definitely know what it is, find out where it is, where you are, but then this is a much lower number than any amount of income tax that you're going to pay. So our first thing, if we're just worried about cost, our first thing to worry about is income tax. So let's look there first. Let's solve that. And then let's look at, okay, so what are the probate fee impacts? And then what things can we put into place, whether it is joint ownership with rights of survivorship. As Lucy said, great idea when that's your spouse. Not necessarily a great idea when that's your kids, not only for that operation of law stuff, but also there's other stuff, lifetime tax on transfer. And then what if your child has a marital breakdown and that asset is on their book? Anyways, it starts to get really, really complicated. And again, probate's just such a small amount that level of work and complexity is often not worth it. So those basic things like joint ownership with your spouse, naming beneficiaries on those registered accounts. Usually for most people, that means that on the first death of the first spouse, there's little to no probate or even income tax to pay. And then it's that second spouse when they go on, unless, they've decided on a strategy of, remarrying. Just keep rolling that over and over again, which can be problematic for the children. So that's a whole other thing. But, the bills really come home to roost on the second death. And then we just want to look at that. Does it make sense? Are we that worried about it? Which part's the biggest part to worry about? And then let's worry about what things we're going to put into place. There's absolutely more expensive strategies than what Lucy talked about. And sometimes they totally make sense. But a lot of times they don't.
And is there
benefit analysis for sure?
Yes.
Is there a specific strategy, relatively simply speaking, to deal with a second property like a cabin in BC or a cottage in Ontario? Or no? Like, is this
define the term simple?
Is a second will or?
Yeah. So one thing to note, at least for Ontario, is real estate outside of the province of Ontario is not subject to probate in Ontario, but it could be, you have your resident in Ontario, but you have your cabin in BC. You wouldn't have probate here on the cabin, but you would have it presumably in BC. Right. An interesting twist on that is the contents of that property would be taxable in Ontario because we do tax movable assets outside the province. So that's where it can get a little bit interesting and different. So a secondary, you may have heard of secondary wills or second wills or separate wills. And they work really well for probate fee planning. And generally speaking, that's what they're for. Simply putting an asset in a separate will does not save you probate fees. But if there is an asset in your estate that doesn't require probate, like a third party is not going to ask for probate, then you can, in Ontario, and I understand in BC, and some other jurisdictions as well, that you can separate that into a separate will. And as long as you have a good definitions of what's in one will and the other will, that works. And in Ontario, we've been doing that since the late 90s, court-approved process. 80 to 85% of my clients have multiple wills for various reasons. So it's very common, nothing nefarious going on. Simply putting a piece of real estate in a second will doesn't help, because that could have, the real estate may have probate because of land titles or registry. However, there's a concept of a bare trust arrangement, which is quite common in Ontario and certainly in Toronto because of real estate prices being, that cost benefit analysis often makes sense. You are allowed to transfer legal title of an asset, real estate, non-registered investments, into a company. And you're not transferring the beneficial ownership. So there's no land transfer tax in Ontario, at least, and no income tax on the disposition, because you haven't actually disposed of your beneficial interest. You've just given the legal title away. And if you have two wills and a bare trust document that supports it, then you avoid probate. So for real estate, we do that. In Ontario, outside Ontario, non-registered investments, in some cases, you can do that too. So that's one of the more sophisticated ways to avoid probate. And speaking of joint ownership, so you were touching on this idea of true joint ownership, where we're concerned with the child being a true owner. They get sued, they get divorced, lose, you put them on title of the house, you lose principal residence for the 100%. Those are all real issues. A probate fee saving strategy is to add a child as a bare trustee. So I gave you the example of a company being bare trustee, but children can be added as a bare trustee as well. And for that to work, though, you need the two wills. So that's an example where simply adding a child on title doesn't necessarily save you probate. You may luck out and it might work, but in most cases it doesn't work unless you've done the proper fulsome planning that goes with bare trust planning.
Normally I watch or listen to my podcasts or YouTube at 1.25 times. But I'm going to go back and re-listen to what you just said at 0.75 times. There's a lot of meat there.
There's a lot of meat there, but as Julie meant, it's a cost benefit analysis. And then when you hire the right estate lawyer, it's their job to very quickly assess, okay, bare trust planning, not relevant or not cost effective. And then to realize when that's appropriate. There are other strategies we haven't talked about, just to highlight, to set them out. Multiple will planning when there are private company shares, very, very common in Ontario. Using an inter vivos trust, a trust today, very popular in BC, but for other reasons because of your will variation legislation, but it does avoid probate too. But you can put assets into a trust now.
Stop. We're going to talk about trusts in the next one.
Fair enough. Just plugging it as a probate fee saving strategy.
Awesome. Well, thank you. Julia, Lucy, we covered a lot on probate. We went deep on probate, although I'm sure we just tapped the surface. There's so much more that we could talk about this, and obviously other topics of interest to our clients and Canadians in general. And so if you enjoyed the conversation today, I encourage you to subscribe to our YouTube channel and be kept up to date on when new videos are posted. And if you have any topics that you want us to cover, please let us know in the comments. And so in closing this second of a three-part follow-up on our estate planning session, we look forward to, in fact, talking about trusts in the next video. Bye for now.